Before you give property to an in-law, you should consider this. Hi, I'm Claire at the Yanowitz Law Firm, where we've been helping families with wills, trusts, and probate for the last 30 years. Okay, let's get started. So, something that oftentimes I find that people don't consider when I'm talking to them about how their assets are going to pass is what's going to happen if their kid dies before they do. You know, the concept of your child dying before you do is such a hard thing to think about that oftentimes I find that people don't really think about that before I meet with them. And so this can get more complicated if their child is married. Okay. So oftentimes, we'll have a discussion around, okay, if your child dies, does their spouse get their share? But I have several kind of follow-up questions that I ask people at that point, and they are as follows. So if you want it to go to this spouse, so let's say your child is Bob and he's married to Mary, okay? And so Bob dies before you do. Does Bob's share go to Mary? And if Bob's share goes to Mary, is that contingent on Mary being married to Bob at his death? Okay, and not legally separated. Okay, so they're not going to be married at that time because Bob's going to be dead. But what if they get divorced before Bob dies? You probably don't want that share going to Mary. So oftentimes we make this gift contingent to a son or daughter-in-law, contingent on them being married to your child at the time of your child's death. The second thing I ask people is, do you want it to go to Mary specifically if she was married to Bob? Or do you want to write it more broadly to say, we want it to go to Bob's spouse who was married to him at the time of his death? The second way of saying it goes to his spouse is broader because, Bob and Mary could get divorced, or Mary could die and then Bob could get remarried to Susan. And so, the question, so if you only write it as Bob's spouse at the time of his death, this could be a new person. So the question is do you pinpoint the name or not? Sometimes if people will just kind of do the nameless spouse, it goes to their spouse. Sometimes people will do this if they have 3 kids, some are married, some are not, and they just want to make sure to just treat all their children equally. So if child 3 gets married at the time, and then then they die, then you want it to just go to their spouse, but we don't know the name of their spouse as of now. So we're just going to use kind of a broad term for it. Something else to think about is, should this spouse inherit outright, or should they inherit in an irrevocable trust at death? So if they inherit outright, they just get the money and they can do whatever they want with it. That money that goes to your in-law, your son or daughter-in-law, could end up going to their new spouse. It can go to their children with a new partner. It could go, it can basically bleed out of your family. And so some people, don't like that. They want to give it to an in-law in a trust that can last for their lifetime. And sometimes we'll set this up so that it's a trust for Mary's benefit during her lifetime, just Mary. But oftentimes we will do what we kind of call a spray trust, where Mary and Bob and Mary's descendants, so the grandchildren of your child, are all beneficiaries of this trust, and the money can kind of be sprayed out between and amongst kind of their nuclear family. Sometimes people will instead opt to take Bob's share and divide it so that, maybe his wife Mary gets half and half goes to the grandchildren. That's another way to handle it, so that it isn't like one pot of money. It's bifurcated into separate shares. So that's another way to tackle this. I would say oftentimes when, a child has not predeceased, we talk about these different scenarios, but I tell people, this is very hypothetical. Your child probably isn't going to die. So let's not sweat the small stuff. Let's make a decision so that, the cart isn't being held up by the horse. Let's get that estate plan done. And then if in the tragic event your child happens to predecease you, that's when it's really important to come back to the drawing board and say, okay, what we put in place, is that what we want? Because at that point, usually there's a lot of clarity on what you want. Our child had cancer for 20 years, and our son-in-law slaved away taking care of our daughter-in-law, and he was an amazing husband, and yes, we want to give him a share. Or, my child got divorced from Mary. We love her, but now he's married to Susan. We don't like her so much, and now our son died, and we don't really want to give to Susan. So it becomes a lot clearer when you're actually faced with the facts, oftentimes what you want to do. So thank you so much for listening today. And if you have any questions, we'd love to help you. Feel free to reach out to our firm at 507-252-8997. Thank you.